Ready? Exercise number 2, Series C, Legal Matter, start. In Mahipal versus Rajesh Kumar under bracket 2020 bracket out 2 SCC 118, a coordinate bench of this court has discussed the scope of jurisdiction of the appellate court in setting aside an order of granting bail. The two key factors for interfering with such an order are non-application of mind on the part of the court granting bail, or the opinion of the court in granting bail is not borne out from a prima facie view of the evidence on record. Stop. Next para. Thus, from cumulative perusal of the judgments cited on either side, including the one rendered by the Constitution bench of this court, it could be deduced that the basic jurisprudence relating to bail remains the same in as much as the grant of bail is the rule and refusal is the exception, so as to ensure that the accused has the opportunity of securing fair trial. However, while considering the same, the gravity of the offence is an aspect which is required to be kept in view by the court. The gravity for the said purpose will have to be gathered from the facts and circumstances arising in which case, keeping in view the consequences that would befall on the society in cases of financial irregularities. It has been held that even economic offences would fall under the category of grave offence, and in such circumstance, while considering the application for bail in such matters, the court will have to deal with the same, being sensitive to the nature of allegation made against the accused. Stop. Next para. One of the circumstances to consider the gravity of the offence is also the term of sentence that is prescribed for the offence. The accused is alleged to have committed such consideration with regard to the gravity of offence is a factor which is in addition to the triple test or the tripod test that would be normally applied. In that regard, what is also to be kept in perspective is that even if the allegation is one of grave economic offence, it is not a rule that bail should be denied. In every case, since there is no such bar created in the relevant enactment passed by the legislature, nor does the bail jurisprudence provide so. Stop. Next para. Therefore, the underlying conclusion is that irrespective of the nature and gravity of charge, the precedent of another case alone will not be the basis for either grant or refusal of bail, though it may have a bearing on principle. But ultimately, the consideration will have to be on case-to-case basis on the facts involved therein and securing the presence of the accused to stand trial. As noted, the appellant has not been named as one of the accused in the ECIR, but the allegation, while being made against the co-accused, it is indicated the appellant, who was the finance minister at that point, has added the illegal transactions, since one of the co-accused is the son of the appellant. In this context, even if the statements on record and materials gathered are taken note of, the complicity of the appellant will have to be established in the trial, and in convicted, the appellant will undergo sentence. For the present, as taken note of, the anticipatory bail had been declined earlier and the appellant was available for custodial interrogation for more than 45 days. Full stop. Thank you very much.